Hey guys, I'm waiting till a few more people get here. This is a live committee hearing on red flag gun confiscation laws.
This hearing today is to examine
So it's a little bit delayed. I'm about 15 minutes or so behind, but I figured I would go ahead and do a stream anyway. I just found the feed. So I'm going to let this play, and this is for gun confiscation hearing. So there we go.
red flag laws, for lack of a better term. We're trying to identify people in our communities that are exhibiting pretty extreme behavior in terms of mental health issues, where they become a danger to themselves and others, and allow law enforcement and sometimes family members to go to a court to say this person needs some help and we need to stop violence before it occurs. There'll be a robust due process component. We'll have a witness to talk about the kind of due process you need to make such a determination. There are 15 states that have a form of this. And one of the reasons we're having this hearing is because of Senator Blumenthal. Nobody has been more passionate about trying to find a solution. It's not the solution that he would prefer sometimes. It's just doing something rather than doing nothing. And Senator Durbin's been that way about immigration for years. So I really do believe that Senator Blumenthal, that after today we can sort of define the problem, that there are a lot of people may be worried, is the government going to come take your guns? And the answer is no. Nobody's going to come and take a gun from you, but there will be a process for law enforcement and family members to petition a court.
Hang on, I'm going to stop it right there. This is live, but, but either way, Lindsey Graham there just said an outright lie. The whole point of red flag laws is to take your guns without due process. For anybody not familiar, you could be something as simple as putting a bunch of guns in the car or truck to go to the gun range. Your neighbor or somebody sees it, thinks you're a danger or a threat, calls the police, they get an order from the judge, they come knocking on your door at 6 o'clock in the morning, telling you to hand them over, you don't have a clue what's even going on. Then they have a court hearing that you're not even a part of, and they say you may get your guns back, if you're deemed not a threat. But by that time, your guns are long gone. Plus, you're tied up in court and all the other mess. So that's an outright lie. And remember, Trump supports this, as well as the NRA. But I'll shut up and let it play.
Court to say that somebody in your neighborhood or somebody down the street across town is about to blow. So I'm a big fan of the Second Amendment. I own firearms, and I try to be responsible in my ownership. But at the same time, every right has limits. And what I'm trying to do with this hearing today is start a discussion about what's working at the state level. Connecticut has a law. And one of the benefits of this law in Connecticut is we reduce suicide rates. The most common form of suicide is through guns, using a gun. Indiana, Vice President Pence was very familiar with the Indiana red flag law. They're about to pass one in Arizona. Florida was the most recent example of a state seizing the moment. The Parkland shooting, and we have a family member here today we'll identify a bit later. The perpetrator, I think is Mr. Cruz, really did everything but take an ad out in the paper. I'm going to shoot somebody. The police went to his house on multiple occasions. The FBI tip line got a call about him saying this guy is dangerous. He had social media postings that showed a very disturbed person, and he acted on it. So Florida, in turn, created a law, a red flag law, Florida specific, to give the law enforcement community a chance next time to intervene before it's too late. And the evidence about how these laws work is pretty impressive. Got some information here about Florida specifically. In Florida, let's see, in Broward County, 108 people were impacted, including 28 cases where the person was accused of domestic violence, 45 from people who were suffering from mental illness, and 34 people were committing suicide. So there's multiple millions of people in Florida, and several hundred have been affected by this law, and that's true pretty much all over the country. And when you look at the people who've been affected, it's probably the best thing that could happen to them, may have saved their life, and I would dare say it probably saved other people's lives. So we're trying to balance the right to own a gun under the Second Amendment with mental health issues that are far too prevalent in society, and we do not have enough capability to deal with the problem. And there are times, like in the Parkland case, where if the law enforcement community had these tools, they could intervene and they could do something about it. And my hope is that what we will do up here in Washington is, I think passing a federal law is probably beyond what the market will bear, but create an incentive at the federal level for states who want to go down this road, making sure that the laws are meaningful and that there's due process for the people who may be on in the court situation, but try to give a nod to the states that this is working in some states. Come up with an idea that's unique to your state, and if you do it in a certain way, the federal government will incentivize you, and I think that's the best way, at least initially, to solve this problem. And I want to thank Senator Blumenthal. Senator Cornyn has been very, very helpful in trying to put the panel together, and we live in contentious times. Maybe this is something we can find common ground on, and I think it would be good for the country. And with that, I'll turn it over to Senator Feinstein.
Thanks very much, Mr. Chairman. Thanks for holding this hearing. We've got a number of members here, and I think that is really excellent. The topic is extreme risk laws, sometimes referred to as red flag laws. I strongly believe that these are important tools that can empower family members and law enforcement to ask courts to keep guns out of the hands of dangerous people. They should at least include requiring universal background checks, closing the Charleston loophole, which would give law enforcement more time to complete checks, and hopefully banning assault weapons. To be clear, extreme risk laws are a vital part of that effort. As of today, as the chairman said, we have 14 states and the District of Columbia passing extreme risk laws. The states are Connecticut, Indiana, my state, California, Washington, Oregon, so you have the Pacific Coast, Florida, Vermont, Maryland, Delaware, Rhode Island, New Jersey, Massachusetts, Illinois, and New York. I've introduced the Extreme Risk Protection Order of 2019, which would create new grants to incentivize states taking similar measures to prevent gun violence. The national discussion about extreme risk laws, or red flag laws as called, escalated after 17 people lost their lives in Parkland, Florida. It was one of the deadliest school shootings in our history. We know the shooter had troubling signs before the shooting. Those signs didn't go unnoticed. In September 2017, the FBI was alerted to a comment the young man made on an online video that said, "I'm going to be a professional school shooter." That's a direct quote. In January of 2018, the FBI got another tip about this young man's gun ownership, desire to kill people, erratic behavior, and disturbing social media posts, as well as the potential of his conducting a school shooting. Then, nothing was done. A month later, he walked into Marjorie Stoneman Douglas High School, armed with an AR-15, took 17 lives, and wounded 17 others. While law enforcement could have done more, this young man's family could also have helped if they had been legally able to do so. And that's one reason why Florida acted quickly after Parkland to pass an extreme risk law. More should be done to address the daily toll gun violence is taking on our country, and I hope my colleagues here today will join me in doing more after today. Since 1994, background checks have stopped more than 3.5 million felons, domestic abusers, and other prohibited people from purchasing firearms. Yet 22% of all gun sales are being carried out without a background check. 90% of Americans support universal background checks. That's for everybody. So why are we not doing the same? Compared with the 10-year period before the 1994 federal assault weapons ban, the number of gun massacres between 94 and 2004, when the assault weapons bill was in law, the number of massacres fell by 37%. The number of people dying from gun massacres fell by 43%. And the fact is that the assault weapons ban worked. Extreme risk laws also work. San Diego has had particular success with California's law. In a little more than a year, that office has obtained 126 orders and confiscated 318 guns, including 33 assault weapons. I'd like to enter into the record, Mr. Chairman, a letter from the San Diego City Attorney. Here is an excerpt from that letter, and I quote, "Our office has found California's red flag law to be a powerful tool for protecting residents and police officers from senseless gun violence. Gun rights advocates closely monitor our work. They have yet to bring to our attention a case where they believe the law was improperly granted," end quote. I thought that the Sandy Hook shooting was a moment when Congress would step up and take action, and I so hoped we would. Despite our best efforts, gun safety legislation was not enacted. Similarly, we saw no action after Parkland, after Las Vegas, or after the many other massacres our country has had to cope with. Unlike the United States, other countries did not miss the opportunity to do something. In Australia, in 1996, 35 people were killed when a gunman opened fire with 2 semi-automatic assault rifles. Shortly thereafter, Australia banned all assault rifles and put in place a licensing system. Now, just days after 50 people lost their lives in New Zealand, that country has also moved to ban assault weapons and high-capacity magazines. So I am hopeful, I guess hope carries eternally, that Congress will once again find the courage to do what's right. We can't forget what happened in Parkland, Thousand Oaks, Isla Vista, Sandy Hook, Las Vegas, Sutherland Springs, Columbine, and countless other cities across the country where gun violence has taken so many lives. We've seen and we continue to see the cost of inaction. So this is a step. It's not a big step. It's a small step. It's a sensible step in the right direction. And I hope my Republican colleagues will join me and support the Extreme Risk Protection Order Act. Thank you, Mr. Chairman.
Thank you very much. And I forgot that in March of 2018, the Trump administration called on every state to enact extreme risk protection orders, and they've been trying to provide technical assistance to all those who step forward. So I thought that was something very noteworthy by the President.
Right.
So our panel is Mr. Ronald Hunberg. Is that right, sir? Yes. Senior Policy Advisor, National Alliance on Mental Illness. Miss Amanda Wilcox, who I think's family suffered a violent crime episode, and sorry about your daughter's terrible thing. Man was mentally ill, came into the mental health facility where your daughter was working. It's terrible, but thank you for taking up this cause. She's the legislative chair of Brady, California. Sheriff Bradshaw is the sheriff of Palm Beach County. He's got a lot of experience about how the Florida law works, and we look forward to hearing from you. Ms. Kimberly Wyatt is Senior Deputy Prosecuting Attorney for King County in Seattle, Washington. And Mr. David Koppel is the Research Director at the Independence Institute, talking about the due process issues involved with this. Mr. Honberg, would you lead us off?
Good morning, Chairman Graham, Ranking Member Feinstein, and distinguished members of the Judiciary Committee. Thank you for giving me this opportunity to testify at this important hearing. My name is Ron Honberg. I'm Senior Policy Advisor for the National Alliance on Mental Illness, NAMI, which is the nation's largest grassroots mental health organization. In my testimony, I want to talk briefly about three things. First, I want to talk about risk factors for violence, including gun violence, that have been identified through research. Second, I want to talk about what we regard as the biggest concern, the use of firearms in suicides. And third, I will discuss NAMI's position on extreme risk protection orders, I'll refer to them as ERPOs, including recommendations for how they can be used effectively without violating individual rights. So just briefly to talk about risk factors for violence identified through research. The biggest risk factor that's been identified is a past history of violence, including domestic violence, a history of physical or sexual abuse, particularly in childhood. Abuse of alcohol or drugs is a significant risk factor, as are past convictions for violent misdemeanors. And then finally, delusions and paranoia, which are sometimes characteristic of psychosis. People experiencing first episodes of psychosis may particularly be at risk. However, it should be noted that most people experiencing these symptoms will not act violently towards others, and particularly if they receive treatment. The biggest concern, and the bigger concern, frankly, is suicides. In 2016, nearly 45,000 people died by suicides. Suicide rates were more than 2 times higher than homicide rates. Suicides were the second leading cause of death in 2016 for young people between the ages of 10 and 24. And the Department of Veterans Affairs has reported that about 20 veterans take their lives each day. Suicides account for 60% of gun deaths in this country, and nearly half of all suicide deaths in the country are with firearms. 90% of suicide attempts with guns result in deaths. The Centers for Disease Control recently estimated that about half of all suicide deaths involved people diagnosed with mental illness, particularly depression, and they speculated that the actual rates may actually be significantly higher because many others have had mental health conditions but may have had mental health conditions, but had not seen a mental health professional and therefore had not been diagnosed. So I want to finish up by talking about NAMI's position on extreme risk protection orders. We feel that when properly utilized, these can be potentially life-saving, particularly in preventing suicides. But to maximize their positive impact and to prevent misuse of ERPOs, we offer the following 6 recommendations. First, determinations of risk should be based on individualized assessments rather than stereotypical assumptions about specific groups of people, such as people with mental illness, that are not grounded in evidence or evidence of individual risk. For this reason, it is neither necessary or appropriate to specifically list mental illness in state or federal laws. It's about identifying people who pose risks for whatever reason. Second, as with any deprivation of personal liberty, it is very important to ensure that subjects of ERPO petitions are afforded due process protections, including notice that a petition has been filed and a hearing scheduled, the right to present evidence in one's own behalf, and the right to periodic reviews to assess whether it is necessary to continue these orders. Third, law enforcement officers assigned responsibility for removing firearms from individuals under these orders should receive training on crisis de-escalation and crisis intervention. The removal of firearms from individuals who are reluctant to give up their guns or who are in crisis can be very difficult and even potentially volatile. And protecting the safety of officers and individuals is of paramount importance. The nationally recognized Crisis Intervention Team, CIT model, is a proven best practice for training first responders and for linking those people who require mental health care with needed services and supports. Fourth, terms like red flag laws should be avoided because they suggest that a particular condition, such as mental illness, is a red flag. The unnecessary use of terminology that reinforces stigma may inadvertently drive people away from seeking help when they need it. And that's why we prefer extreme risk protection order or gun violence restraining order as the term to use. Fifth, authority to initiate petitions for ERPOs in state law should be expanded to include health professionals. Most existing laws currently limit standing to petition to law enforcement officers and in some states family members. While we respect the importance of protecting the therapeutic alliance between health professionals and their patients, we also recognize that these professionals are best positioned to recognize crisis situations and when their patients may be at risk of harming others. And finally, resources should be available to educate key stakeholders about these orders and how to use them. And this would include funding for training and technical assistance for law enforcement, lawyers, judges, health and social service providers, and family members. I have a more extensive written statement which will be part of the record. Thank you for this opportunity to testify about ERPOs and their implementation in states, and I look forward to your questions.
Thanks, sir. Ms. Wilcox.
Good morning. Chairman Graham, Ranking Member Feinstein, and distinguished members of this committee. Thank you for the opportunity to come before you today to share my story. My name is Amanda Wilcox, and I'm the legislative chair of Brady, California, a network of grassroots chapters dedicated to ending gun violence. I have been a volunteer gun violence prevention advocate for the past 18 years. In January 2001, my daughter Laura was home on winter break from college and filling in as a receptionist at our county behavioral health clinic when a client came in and opened fire. He shot Laura 4 times at point-blank range, killing her instantly. When his rampage at the clinic and a nearby restaurant ended, 3 people lay dead, 3 were severely injured, a community was left shaken, and the world was diminished by the loss of an incredible young woman. Laura, bright and beautiful at age 19, had extraordinary capability, kindness, and spirit. She was an outstanding student, graduating as high school valedictorian, and was at the time of her death a sophomore at Haverford College and in the midst of her campaign for the student body presidency. Laura was already living a life full of service. She wanted to make a positive difference in the world. She had unlimited possibilities and the brightest of futures. After Laura's sudden death, my life and that of my husband Nick was turned upside down. We were in a state of extreme shock, emotional pain, and deep grief. Later, as we struggled to comprehend the circumstances of our daughter's death, we learned that the shooter's family, girlfriend, and caseworker were all worried about him. His father and grandfather had died by suicide with a firearm. They knew he had guns. The warning signs were there. But because he had never committed a crime or been subject to an involuntary mental health hold, which carries a temporary firearm prohibition under California law, there was no legal tool for removing his firearms. It was clear to us then, and it still is today, that there needs to be a way to remove firearms from a person who is in crisis, clearly dangerous, and at risk of harming themselves or others. It was too late for Laura, but my husband and I wanted to save others by working to keep guns out of dangerous hands. Since Laura's death, there have been many high-profile shootings in Tucson, Aurora, Isla Vista, Parkland, and in so many cases, there were warning signs and people were concerned. And every day, there are shootings that most of us never hear about. But in my small rural county, 4 people I know have died by suicide with a gun. And in my own little town, an elderly man with dementia shot and killed his caregiver. In so many shootings, whether suicide, domestic violence, mass or school shooting, a loved one or member of law enforcement typically sees the signs before the tragedy occurs. The Extreme Risk Protective Order law allows family members and law enforcement to petition the court for a temporary firearm prohibition when a person is at risk of injury to self or others by having a firearm. The law enables those who know the person in crisis the best, family members, or law enforcement, to intervene and save lives. My central role in the enactment and ongoing implementation of California's extreme risk law has been very meaningful to me. As had the law been in place in 2001, Laura might be alive today. Based on our experience in California, I know that extreme risk laws need to be accompanied by a thoughtful and robust implementation program that incorporates all major stakeholders, including law enforcement officers, court clerks and judges, as well as social service providers, medical professionals, and other.
Hang on a second. I want to intervene here real quick. This is what always has caught my attention about all of this. They're talking, take your guns. All right. Pick any of us. We could all fit into this. You get some crazy nut out there. Maybe he is legitimately a nut. So they come 6 o'clock in the morning, confiscate all of his guns. All right. What stops him from going out after everybody leaves and, let's say, gets a car or some other means and still goes out and kills a bunch of people, or breaks in a neighbor's house and gets some more guns? It makes absolutely no sense. Taking the guns away is not going to prevent the act if the person really wants to commit it. He's not in jail. You're not getting arrested or any of that. You're still free to do whatever. So that's a huge flaw to begin with. Take all the guns, you could take somebody's car, but if they really want to drive, they can smash out the window of the neighbor's car, hotwire it, and take off. There's nothing you can do short of locking him up, which if somebody is that dangerous, then maybe they should be locked up. I don't know. It just makes no sense to say, you're so dangerous you cannot have a firearm, but yet we'll still let you walk the street and carry on your day-to-day life. That makes absolutely no sense whatsoever. Sure, chainsaw, anything, any number of things. So that right there proves every bit of this is just stupid. Now, the only people this will stop from committing an act of any kind is the ones that were never going to carry through with it in the first place. Those kind of people, they never had any intentions of it. You could just say boo and, they're done. They quit. But to take somebody's guns or car or anything, to take away anything from them does not prevent them one way, shape, or form from committing the act. That just, I don't know. And I've never got a straight answer from any leftist nut job out there, which you never get an answer anyway. But, they've never even given me a half answer of how that would work. So, alright, here we go. There's at least another 30, 40 minutes of this. I don't know how long it lasts, but we'll keep going. This is live, but it's just a little delayed.
Others who may be working with a potential family petitioner. A process for implementing the law in each jurisdiction needs to be developed. This takes resources. As a mother whose daughter needlessly lost her life, I ask you to support incentives and funding for states to enact and implement extreme risk laws. We can save lives every day by making extreme risk orders available throughout the country. I look forward to working with all of you on this committee to find a path forward. In 2001, Laura was killed in an instant by 4 bullets. In the aftermath, I was overwhelmed by the permanence of her death. Laura was gone forever. That is why extreme risk laws resonate with me. One can always give a gun back. I cannot get her life back. Thank you.
Thank you very much, Ms. Wilcox. Sheriff Bradshaw.
Good morning, Chairman Graham, Ranking Member Feinstein, and distinguished members of the committee. My name is Rick Bradshaw. I'm the sheriff of Palm Beach County. I've been the sheriff there for 15 years. Before that, I was the police chief in West Palm Beach, and I worked there for 33 years. I really appreciate the opportunity to be here this morning to speak with you about what I believe is probably the one of the most important issue in the United States right now, and that's the high level of violence that's taken human lives. This issue has been kicked around a lot, and there's a lot of diverse opinions about it, but the violence is really either domestic violence, street violence, or what we've seen with the mass casualties, targeted violence. The recent studies indicate that the domestic violence and street violence incidences are more often the result of an impulsive or reactive situation. On the other hand, the active shooter mass casualty incidents appear to be predatory and planned, where the violence is premeditated and serves some purpose for those who plan and conduct the attacks. Another aspect of the perpetrator at some point in time displayed pre-attack behaviors or shared information that gave clues to others about their impending violence. It is incumbent upon law enforcement to continue to connect with the community and provide avenues for them to communicate information about their concerns to their respective law enforcement agencies so that information can and must be acted upon. Finally, there's a relationship between mental illness and targeted violence. It's complex and no means by absolute. To be very clear, without a doubt, all mentally ill people are not violent and do not commit violent acts. But the research has shown that those involved in these acts do have and have demonstrated intentions that are indications of their behaviors, because behaviors are clues to a person's intentions and are the foundation of any mental health diagnosis. Law enforcement must carefully consider each individual case, assessing the impact of that mental illness that may have on the person involved and taking the appropriate action. Law enforcement must educate and must train its personnel in mental health issues and employ mental health professionals to be part of the risk assessment teams. Once a person or persons have been identified as a personal and potential risk and may be involved in a violent act and may be in possession of firearms or likely to purchase one, then the use of the risk protection order appears to be a valuable tool. And I stress that phrase, tool. It's not the end all. Our goal here is to identify people that have the potentiality to perform these violent acts. Because it could be a car, it could be a rock, it could be a knife, it could be a pressure cooker. So sometimes it's not the instrument, it's the hands of who you put this instrument in. My testimony today will be discussing how the Sheriff's Office has developed a strategy, a special unit called the Behavioral Science Division to address these issues. I think the most important thing to realize is we cannot arrest our way out of this situation. Prevention, intervention are the key factors to resolving this issue. Having such a unit as the Behavioral Science Division with the capabilities of using that risk protection order and the mental health professionals attached to it will reach these goals. I've submitted a larger statement that details our program, the interventions, and our success stories. It's about prevention. It's not about the gun taking. We want to identify these individuals, get them the help they need before they commit these violent acts. I look forward to your questions and the discussion going forward. Thank you.
Ms. White.
Good morning, Chairman Graham, Ranking Member Feinstein, and distinguished members of the Senate Judiciary Committee. Thank you for the opportunity to testify and for your leadership on this critical, life-saving tool, extreme risk protection orders. My name is Kim Wyatt. I am a senior deputy prosecuting attorney from King County, Washington. For the past year, I have served as a firearms prosecutor in the Regional Domestic Violence Firearms Enforcement Unit, specifically as the Extreme Risk Protection Order prosecutor. My responsibilities are to advise and assist law enforcement and family members on all aspects of extreme risk protection orders, from the petitions to the court proceedings. And I can tell you this has been some of the most important and rewarding work of my career. You see, as a prosecutor, rarely, if ever, do we get the opportunity to intervene prior to the gun violence occurring. Instead, we react. We receive that incident report after the crime has occurred. My colleagues and I know we have few brief windows of opportunity to intervene to prevent future harm. This life-saving legislation creates one of those opportunities and allows much-needed intervention to prevent suicide, homicide, and other acts of community violence, while at the same time protecting people's constitutional rights with due process built in. Red flag laws or extreme risk protection orders allow family members and law enforcement who have seen those warning signs to come before a court and petition for a temporary order that prevents the at-risk individual from purchasing and possessing firearms. In 2016, Washington state voters overwhelmingly approved a citizens' initiative for our extreme risk protection order, passing by 69% of the vote. To understand what we've been doing in our state and the cases that I see every day, I need to tell you about some of the stories. These are stories of people who are at their lowest and most vulnerable points of life. The first story I want to share with you is about a case that we believe prevented a suicide. A woman filed an extreme risk protection order against her boyfriend as he had recently tried to commit suicide and wanted to purchase a firearm. At the extreme risk protection order hearing, they came in together. In fact, they were holding hands. The boyfriend or respondent had no objection to the extreme risk protection order and in fact expressed gratitude that somebody cared enough to make sure that he did not have access to a gun while he was in a crisis. We've also dealt with cases involving crimes of violence. Recently, in the end of January of 2019, police were contacted by a doctor who stated that they had a client who was making reference to a hit list. Specifically, the client or patient wanted to obtain a concealed pistol license and purchase a firearm. In reference to this hit list, he said doing them harm was his duty. Law enforcement were able to intervene, obtain an extreme risk protection order, and during their investigation, they verified that the day that the respondent had made the comments to his therapist about the hit list was in fact the very same day that he went down to our local sheriff's department and applied for a concealed pistol license. Law enforcement were able to retrieve the concealed pistol license, file the extreme risk protection order, preventing this individual from being able to legally purchase a firearm in our state. We have also worked on cases involving threats to our schools, as evident by the recent tragedy at Stoneman Douglas High School and too many others. We have an ongoing responsibility to protect our children while attending school. In May of 2018, law enforcement in King County received a report about a student, this was a university student, that was making threats to kill other students. Specifically, he stated, "I could just kill you all. Would it be easy? It would be easy to kill everybody." And then he went on to describe what firearms he would use to kill them. Law enforcement intervened, filed an extreme risk protection order, and then secured the firearm that he had to make sure he did not have access. Although all of these cases described above are factually different, there is a common thread. All involve someone experiencing a behavioral health crisis or exhibiting violent behavior and having access to firearms. What we have learned over the past year is that the time to act to prevent future tragedies is upon us. What we see in Washington state is that this law is working to save lives. Every state in this nation deserves to have this tool, the ability to react quickly to threats of suicide and homicide and prevent irreversible violence. This is what the public expects and, most importantly, deserves. Thank you.
Mr. Koppel.
Thank you, Chairman Graham and Ranking Member Feinstein. I support laws to remove firearms from people who pose...
Turn
sorry.
Turn your... There you go.
I support laws to remove firearms from people who pose an extreme risk, not based on some lesser standard as some bills with an extreme risk title, but very different text do. In 2018, the Conference of Chief Justices asked the Uniform Law Commission to draft model legislation. I served on the Uniform Law Commission's study committee on the topic. While the study committee members had very diverse expertise and viewpoints, we were nearly unanimous that the Uniform Law Commission should move forward to draft a fair and thoughtful national model. Unfortunately, the Uniform Law Commission's efforts were shut down by lobbying from gun control organizations. As they frankly stated, they did not want any competitor to their own model, which in my view is dangerous and unbalanced. Federal funding should reward states only for best practices which protect civil rights and public safety. The first problem to address is the frequent misuse of ex parte confiscation orders against innocent people. Any procedure that allows a judge to hear only one side of a case necessarily will produce a very high error rate. Data from the 2 states with the oldest confiscation laws so illustrate. In Connecticut, confiscation orders may be issued ex parte. Later, the respondent will have an opportunity to tell his or her side of the story in court. In Connecticut, once the respondent does have a chance to tell his or her side of the story, 32% of confiscation orders are overturned. A study in Marion County, Indianapolis, reported similar results. Error rates for newer laws are likely to be even higher. Connecticut requires that a petition be filed by 2 law enforcement officers, and they must have conducted an independent investigation. Indiana likewise requires that petitions be filed by law enforcement. But some states allow petitions to be filed by a very wide variety of people, not just family members, but even including ex-girlfriends and ex-boyfriends or distant cousins, who may have had little or no contact with the individual for years. These states have no requirement for corroboration of any evidence. Indeed, Colorado's House Bill 1177, which will soon become law, legislators removed a requirement that evidence be corroborated. Unreliable procedures for ex parte orders ensure that a very large amount of orders will be issued against innocent and peaceable individuals. The problem is aggravated by mandates in some states for automatic, no-notice surprise confiscation, which may be perpetrated by no-knock raids. One person, Gary J. Willis, a 61-year-old black man, has already been killed by that system. Last November, a month after Maryland's new confiscation law went into effect, police in Ferndale, Maryland showed up at Mr. Willis's house at 5:17 a.m., announcing they had come to take his guns. They talked for a while, then argued, and then the police shot him to death. The victim's niece said that her late uncle likes to speak his mind, but wouldn't hurt anybody. I'm just dumbfounded right now, she continued. They didn't need to do what they did. In the Maryland-style systems, a respondent never receives notice of anything until the police show up to confiscate his or her firearms. This creates an inherently volatile and dangerous situation for law enforcement and the public. The safer approach is to authorize no-notice or no-knock confiscation only when a court has made specific factual findings about why such an approach is needed. Given the dangers imposed by autopilot confiscation, it is no wonder that so many sheriffs around the country are refusing to put their deputies and the public in harm's way to enforce a confiscation order that has a high possibility of being wrong and that can easily be obtained by a spurned former dating partner or a distant relative. As detailed in my written testimony, government attorneys sometimes discourage people from having counsel at these hearings, even at their own expense. A former Connecticut prosecutor bragged about how he talked respondents out of using lawyers. Colorado is taking steps to prevent such abuse by making court-appointed counsel available to all respondents. But a lawyer can't do much if she is prevented from cross-examining adverse witnesses. Some states eradicate the right of cross-examination. The accuser and witnesses supporting the accuser need never testify in court, where they would be subject to cross-examination and where the judge could observe their demeanor and make a decision about credibility. Instead, persons can simply submit an affidavit. In some states, the petitioner will never be seen by a judge or by opposing counsel. They can make a telephone call at an ex parte hearing and then immunize themselves from cross-examination at a later hearing simply by filing an affidavit. States that thwart cross-examination, promote unnecessary no-notice, no-knock raids, may have or leave innocent victims without a civil remedy for false or malicious petitions, or which deny other core elements of due process, should not be rewarded with federal funding. Federal funding should support best practices and not the worst. Thank you.
Thank you all. That was excellent. Gives us a lot to think about. Sheriff Bradshaw, if the law that exists in Florida existed before the Parkland shooting, do you think it would have mattered?
Well, absolutely. And again, I have to go back to the total picture here. And the reason I explain that is although it didn't happen in Palm Beach County, we actually dealt with the brother of Nicholas Cruz the next day. And he had made some statements, made some gestures that he was going to go back down there and finish what the brother had started. The deputies responded to that location, contacted him. My behavioral sciences unit went there, spoke with him, determined that he was actually a danger to himself or the public, and took him to a mental health facility to lodge him for 72 hours, which took him out of the system, off the street. We spoke with the parents there, asked them if there was any firearms. They said no. Did he have access to some? No, he did not. That's how the system should work. It's my belief that in Broward, you had 3 or 4 different agencies that knew this individual was a problem, knew that he had issues that he was dealing with. And again, I go back to the fact, just because somebody's mentally ill doesn't mean they're violent, but these people demonstrate mental illness issues. He had those issues. He had bullying issues from his brother. He had self-esteem issues. He had other issues that were playing themselves out. But he kept getting recycled into the system. If they would have had the type of unit that I have developed where you have a deputy sheriff and the mental health professional as a team, and they are able to evaluate this system, this person, and get them to the place that they need to have help, then Nicholas Cruz would have been taken out of that system and not being available to do what he had to do.
Before the current law was passed, was there any avenue for law enforcement to act?
Only if we had an arrest, right? It's easy when you make an arrest, you seize the property.
Right. But without an arrest, the answer is no.
No, and that's why they kept cycling this kid back through the system.
Gotcha. Ms. Wilcox, do you think it would have mattered in your daughter's case if the California law had existed at the time?
I believe the law could have saved her life. As I said, those around Scott Thorpe, that's the man who killed my daughter, were very concerned about him. He actually had been evaluated for what we call a 5150 hold in California, the involuntary 72-hour mental health hold, and he was able to hold it together and not meet the criteria for the mental health hold. But this would have empowered his family members to take some action to remove the firearms.
Given a tool. Ms. Wyatt, how many people are in the state of Washington?
Ooh, I might get in trouble for this one. Can you hear me?
There you go.
Okay, thank you. I believe...
You don't have to give an exact.
Okay, I'm not quite sure. I believe it's either 6 or 7 million people. In King County, where I'm from, there's a little over 2.2 or 2.4. It's been growing.
How many people have been affected by this?
By the extreme risk protection order?
Yeah.
I don't know the numbers statewide because we don't have a very...
In your county?
In my county, I can tell you our unit or myself, we've worked on 70, in 2018, 70 extreme risk protection orders.
Okay.
And the vast majority were initiated by law enforcement.
Okay. Mr. Koppel, what state do you think has it most right?
I think Vermont sets a good model in terms of the ex parte proceeding. In Vermont,
I wouldn't have picked that one, but that's good.
Okay. And in Vermont, ex parte confiscation can only be ordered when there is the judge finds that there is an extreme and imminent risk. And Vermont also has, and confiscation can be ordered later after a due process hearing.
Do most of these states have a clear and convincing evidence standard for final disposition?
For final disposition, that's correct. But the one problem is the ex parte standards hearings can be on such low standards.
I got you. Ms. Honberg, when it comes time to kind of help people like Sheriff Bradshaw, if we pass any legislation incentivizing states to create a protective order system, how much is the mental health professional part of it? How should we focus our attention there?
Well, Senator Graham, there's no question that our mental health resources are inadequate pretty much across the country, but I agree that if in fact the removal of the firearm is related to a mental illness, that we need to be thinking about how we can link
Seems
people
like
with
Sheriff
treatment.
Bradshaw's concept makes a lot of sense. You just need the resources to make it happen.
I agree. I think that with the caveat that not all of these cases involve mental illness,
Sure.
but for the ones that do, yes.
Senator Feinstein.
Mr. Chairman, Mrs. Wilcox, it's hard to know what to say, but your strength, your grace, your comments, the cogency of those comments, my heart goes out to you. And thank you so much for fighting the fight. And I deeply believe one day people in this country are going to see the light and do something about guns. I hope I'm alive to see it, but thank you so much. Family and law enforcement were aware that the shooter in Parkland, Florida, showed warning signs, yet no one could legally do anything about it. And shortly thereafter, Florida passed extreme risk legislation, and our new colleague, Senator Scott, signed it into law. Simply put, there really is no question that school shooters can show warning signs that could give law enforcement and family members a chance to stop the next tragedy. Sheriff, do you agree and do you support this kind of legislation?
Absolutely. And I could go back and talk about the success stories we've had. We've only had to do 16 risk protection orders. Lots of times the cooperation with the family is excellent, and they'll turn over the firearms because they wanted to get rid of them anyhow. But I don't want to go back and beat this horse to death, but I cannot begin to tell you, if you're going to stop the threat and the risk assessment teams are going to work, it's imperative that you just don't rely on the law enforcement. My law enforcement officers on the team, the deputies either have a master's or a PhD in psychology or social services. But we bring a clinician from the community, I hire them, and I put them together with that team. So when I send them there, lots of times they've either dealt with those people, but they bring that expertise over and above the normal deputy. We can teach the deputy this CIT, but that doesn't give them the tools that they need. And the risk protection order is not the end-all. It's just another tool in the toolbox to use to make sure that once we identify this person that has that propensity to do what they've indicated they're going to do, which this kid in Parkland did several times.
Yes.
Right? And he should have been taken to a facility to get the help that he needed. But again, they kept recycling him through the system because certain times there's not a crime that's been committed, but with the right assessment team, you can take him out of that system, get him where he needs to be, remove the firearms that he had access to, and now you've resolved that problem.
Does anybody disagree with what the sheriff has just said? I thank you for that, because coming from somebody who is a professional, and it's such a clear and definitive statement, and I don't think anybody in this room challenges that it is also a correct statement. So thank you very much, and I'm going to yield, Mr. Chairman, for others.
Mr. Koppel, these laws that we're talking about gives a judge an opportunity to take a gun away from people that are a threat to themselves or other people, but it also comes up against the Second Amendment right, and I'd quote, everybody knows this quote, "The right of people to keep and bear arms shall not be infringed." So, would you agree that the appropriate level of judicial scrutiny for the Second Amendment is strict scrutiny?
It depends on the particular law, but this case, which deprives people of having a firearm in their own home, yes, at least strict scrutiny.
Okay. Would you agree, same person, would you agree that it would be inappropriate to deprive U.S. citizens of their constitutional rights, even temporarily, without robust due process protections?
Yes, because the period when somebody is disarmed is a period when they're vulnerable, and without good due process protections, these laws can be abused by stalkers and other domestic abusers who want to temporarily disarm their intended victims.
Isn't it possible, Mr. Koppel, that some of the red flag laws that have already been passed by state legislatures could be held to be unconstitutional because they don't have enough due process protections in place?
Certainly, that would often depend on state laws. But for example, some states say that the right of cross-examination in all cases, not just in criminal cases, is an essential part of civil rights and due process and the common law.
This would be your opportunity to give some suggestions to what due process protections would you recommend for red flag laws?
In addition to the strict controls on ex parte proceedings, only having those when there's a showing of necessity and not making them a matter of default, providing counsel for all the accused or the respondents, and I think having a robust civil remedy for people who were falsely accused. Again, we know from Indiana and Connecticut that about 30% of these are wrongly issued. Now, sometimes those are maybe just a matter of good faith mistakes, but other cases it could be abuse in family disputes or romantic breakups and other situations. And there is the technical possibility of a perjury prosecution, but those are very rare almost around throughout the country, even more so in civil cases. So I'd say the victim of a false or malicious petition should have the right to a civil remedy to recover attorney's fees and damages. And in addition, the whatever restrictions states have on their no-knock raids should certainly, such as in Colorado, require the district attorney to get a warrant from the court before a no-knock. Those should apply to these kinds of confiscations as well. And unfortunately, the Colorado bill doesn't include our standard protections against no-knocks.
Okay. Various state laws and bills that are in Congress have varying standards that include substantial likelihood, probable cause, preponderance of evidence, and clear and convincing evidence. What is the appropriate standard that you'd like to see in red flag laws if Congress were to legislate?
The standard of proof at both at the final hearing and at the if there's an ex parte hearing where there's no opposition, so it should be fairly easy to win that one, should be clear and convincing evidence. And I think if we're going to have truth in legislation, when a bill says it's about extreme risks, then the standard should be a finding of an extreme risk, not a finding of some lower level of risk, or as in some legislation, merely finding a danger. Well, anti-gun advocates would probably say that every citizen who has a gun poses a danger, so that's much too low a standard. Clear and convincing finding of extreme risk, I think, would be upheld by the courts as compliant with District of Columbia versus Heller.
My last question would have to be, Ms. Wyatt. You mentioned in your testimony that you're a prosecutor and extreme risk protection orders. What would you agree that laws affecting the Second Amendment rights should be reviewed under strict scrutiny? Well, and then let me follow up with this, and then this will be the last one. Would you agree that the appropriate evidentiary standard for these orders is clear and convincing evidence?
So to your first question,
No, back on.
Sorry. To your first question regarding strict scrutiny, I don't have concerns about our particular statute because due process is built in at each phase. And I can help explain that if that's helpful to the committee, specifically that anything that we do with law enforcement or a family member that's coming to petition is coming before the court. So there's nothing that's being done on their own accord. It all goes before a judicial officer. They are filing out a petition that's sworn under penalty of perjury. Then they're also going into court and attesting to those facts, once again being examined at the ex parte phase as well. So I don't have concerns about that particular prong in our statute. To your second question about the clear and convincing, I can just give you the perspective of our state. We have a 30-year protection order history in our state. All of our orders, our civil orders, including our extreme risk protection order, sexual assault, domestic violence, stalking orders, are all done initially by a preponderance. And that's the perspective that I offer because that's what's worked in our state.
Senator Durbin.
Mr. Koppel, have you ever met Congresswoman Gabby Giffords?
I have not. I've met her. I sat next to her husband, Mark Giffords.
Turn on your microphone. Did you turn on your microphone, please?
Turn your microphone.
I'm sorry. No, Senator, but I did sit next to and meet her husband, Mark Giffords, when he and I testified before this committee a couple years ago.
It's interesting, you didn't mention her name in your oral testimony, but in the written testimony submitted to the committee, you've mentioned her 18 times.
The Giffords organization, yes.
Yes. And the point I want to make is that many of us sitting at this table have town meetings. She had a town meeting on January the 8th, 2011. A gunman came into that meeting and killed 6 people, including a federal judge and a 9-year-old bystander girl, did damage to her, which she still struggles with to this day. And this gunman, whose background has been described, is, let me just read it to you if I might. I'm not going to mention his name, he doesn't deserve it. Acquaintances say his personality had changed markedly in the years prior to the shooting, a period during which he was abusing alcohol and drugs. He'd been suspended from a local community college because of bizarre behavior and disruptions in classes in the library. After his arrest, 2 medical evaluations diagnosed him with paranoid schizophrenia and ruled him incompetent to stand trial. What point I would like to make to you is Congresswoman Giffords is one of our colleagues. She was doing what we do every day. She went to a town meeting just as Miss Wilcox's daughter went to work. Her life is forever changed and 6 people lost their lives. I believe that we ought to err on the side of protecting innocent people. I hope you believe the same thing. I'm glad you didn't mention her name in your oral testimony, but I have a great admiration for her and her husband and the battle they have fought ever since so that innocent people like her, just going about their daily lives, don't become victims of someone who is clearly in a position where they should never own a firearm. I also want to say a word about your comments on domestic violence abusers. You have some pretty strongly stated views here about abusers abusing this system. And yet when it comes to the National Coalition Against Domestic Violence, they support these laws, which are a vital tool to protect people experiencing crises that make it temporarily unsafe for them to possess a firearm. These are the experts on the subject. They don't buy your point of view.
Well, I support these laws too, Senator. That's why I'm here testifying. And I would just remind you that with I'm glad you didn't mention the name of the Arizona criminal. As I detailed in an article in the Howard Law Journal, there was already all the procedures in place under Arizona state law to have that person confined for mental health evaluation. The Pima County Community College, where he was attending, dropped the ball. They expelled him because he was known to be dangerous to them. And if they'd simply taken one more step and notified a local sheriff's office or someone like that, he could have been taken care of under existing laws.
Mr. Koppel, let me tell you, existing laws did not save the lives of 6 people killed by this man. What we're talking about is a step forward to protect innocent people like Laura Wilcox and others beyond the existing law, which by its definition may provide protection, in reality did not. And what we're trying to do is come to a safer conclusion. Sheriff Bradshaw, one of the things that I worry about is sending law enforcement agents to a household where we know that someone has been ruled dangerous or is ineligible to own a firearm and asking them to come back with that firearm. That is a pretty dangerous assignment, is it not?
It is, and I'd like to go back to what you're talking about. And I cannot stress enough the importance of having these risk assessment prevention teams teamed up together, not only with the law enforcement agency, but have these mental health professionals as part of this team. All right? When you talk about the due process that they're talking about, where you need to have this clear and convincing and make sure that there's extreme danger, just having the deputy testify may be okay, but when you have that professional there that can explain it, that can say, listen, I'm a clinician, I'm looking at him, he is an extreme danger, then the court gets that sense of, yes, this is the right thing to do, this is the right order to put out there to take this firearms away from these people. And again, I cannot stress enough, the firearms are one thing, but think about it. People are using cars, knives, rocks, guns, pressure cookers. I mean, in Boston, Do you know they went as far as saying, you know what, maybe we need to serialize pressure cookers and make it to where it's 21, you can't buy one. Really, folks? All right? You need to identify the people that are going to go get a weapon and keep that out of their hands. It's that simple.
Thank you, Sheriff. Well, I'd like to just close by saying to Mr. Honberg, thank you for being here. We need to remind ourselves during the course of this conversation that mental illness is an illness. It is not a curse. There are people suffering from mental illness that are no danger to any other person on earth. In fact, are more often victims than they are perpetrators. But having said that, there are those who are likely to cross the line, and we never want that to happen if we can avoid it. Thank you.
Thank you, Senator Durbin. I could not agree more, and it's very important that we not conflate mental illness with criminality, because most people with mental illnesses are not criminals. And I also think that it's really important for us to keep in mind that with these orders, the most lives we save are going to be people who are at risk of taking their own lives.
That's right. Thank you.
Senator Cornyn's next. One quick question, Mr. Koppel. Is Arizona involved in trying to pass an extreme risk law?
It was up in the legislature last year, didn't pass, and I presume it's a matter of legislative activity again. But again, whatever the pros or cons on that, the man who attacked Gabby Giffords, there were all the tools there to have dealt with him beforehand.
Yes. Senator Cornyn.
Thank you, Mr. Chairman, for holding today's hearing, and appreciate all of you being here. I find it useful to ask myself, what problem are you trying to solve when we approach complex issues like this? Are we trying to keep guns away from people who are ineligible under current law? I'd say yes. Are we trying to keep guns away from people who are exhibiting mental illness and are a danger to themselves and others? I would say yes. Are we trying to keep guns away from law-abiding citizens that are neither ineligible nor suffering from mental illness? I would say no. Should we harden the targets that people use to attack or engage in gun violence? I would say yes. You don't hear much about people going into a police station with guns ablazing. They go into schools and soft targets. And so, to me, that should help direct our thinking. With the help of a number of you, Mr. Honberg, and you in particular, NAMI, we have worked on the mental health aspects of this problem. And just so people don't think we've done nothing, let me just point to the 21st Century Cures Act and the Mental Health and Safe Communities Act, which was part of that, which was an effort to try to deal with the mental illness issue. Every time I think about Adam Lanza and his mother in particular, at Sandy Hook, she knew her son was mentally ill, and she simply did not have the tools available to deal with it. She could try to get him involuntarily committed, and he'd be mad when he came back 72 hours later, and he still would be non-compliant and with his doctor's orders to take his medication and the like. So, Ms. Wilcox, I believe you've been active on assisted outpatient treatment as one potential way to address this problem. Again, if you are a son or if you are a spouse or a sibling of a person with mental illness who's an adult, it's very hard to know how to deal with that. But the assisted outpatient treatment allows you to go to a judge in a civil context, petition for essentially a court order that will require them to show up for their doctor, to see their doctor and take their prescribed medication. Do you think that is a piece of the puzzle here?
Clearly, I think it's a piece of the puzzle. Our AOT scheme in California is called Laura's Law, named after my daughter, Laura. We need many tools in the toolbox. One, of course, is getting people into treatment, particularly those who are so ill that they don't recognize that they need treatment. Right. And that's what Laura's Law is for. Interestingly, my work on Laura's Law, which was back in the early 2000s, really helped move the legislation forward, the IRPA legislation forward in California. With both of these laws, we recognize, and you certainly as policymakers are well aware, that you have the task of balancing public safety and civil rights.
No doubt about that.
And can we find that right balance?
Sure.
And we had to make that same point for Laura's Law.
Well, thank you for that. I know my time is limited, so if you'll let me get to a couple other questions. Of course, after the Sutherland Springs shooting that Senator Cruz and I unfortunately had in our state, right outside of San Antonio, 26 people killed by a person who we know was disqualified under current law from purchasing a firearm. And what he did is he lied, and because the Air Force didn't upload the derogatory information on the background check system, he was able to get those guns and kill those people worshiping that Sunday morning at a small Baptist church there in Sutherland Springs. We passed a bill, a bipartisan bill called the Fix NICS, the National Instant Criminal Background Check System, to require federal agencies like the military to upload that information and to incentivize the states to do the same. And I'm proud of the work that we've been able to do both on dealing with mental health issues as well as the background check problem. Of course, one of the things, I think, Mr. Koppel, you mentioned that something about protective orders in domestic violence disputes. Interestingly, as I recall the law, if you are the subject of a protective order, you are already legally disqualified from purchasing a firearm under existing law. Is that your recollection?
That is correct, with some details on the facts of the protective order, yes.
Right. And Mr. Honberg, I appreciated your comments about the particularized showing in each individual case, not treating people categorically, but individually. I believe, Ms. Wyatt, you made the same point. For example, would you support these sorts of extreme violence, protective orders issue against people with post-traumatic stress syndrome?
I think thank you, Senator. I think it really depends on the particular case. Not everyone with post-traumatic stress disorder poses a risk of violence to self or others. And I think the treatment is obviously the most important service you can provide someone. But there may be some individuals who do pose risks to themselves or others, and having the availability of these extreme risk protection orders could be very, very helpful in removing the firearms temporarily from that person to basically protect that individual.
With the chairman's indulgence, let me just express my gratitude to you, Sheriff, for your mentioning the suicide problem. 60% of gun deaths are suicide. People take their own lives. But of course, there are other means for them to do so, even if they didn't have a gun. And you made that point with a car, drowning, a rope, other means. So this is more complicated, perhaps, than many of us have appreciated, and appreciate your adding that texture and context.
Absolutely. Can I make just one comment on something that you said very quickly about the background checks? In Florida, if you want to get a carry and concealed weapon permit, there's a form you fill out. They give it to you, and it says, you ever been arrested? You ever been this? You ever been in a mental institution? Who in the heck's going to check yes? Nobody, right? But if you go back to the database to find out if this person should get it, that information is not in the database unless you've had something where a court of jurisdiction has actually lodged you in there, or you have some other type of system that can get that information. So if there's one thing that needs to be added to the database, is the ability, and not again to stigmatize everybody that's been involved in mental health issues, but if you've had this contact with law enforcement where you've had to have your firearms taken, or you have been adjudicated, or you've had continually had contacts where in Florida it's a Baker Act where we lodge you into these institutions, somehow we've got to get around this HIPAA thing where that information is in there so the people that are issuing these licenses or selling these guns, they can check the criminal background, but they don't have that information now.
Along those lines, I've been told there may be up to 1 million adjudications in the country where somebody's been rendered a danger to themselves or others at some state proceeding that are not into the background system. Huh? Senator Klobuchar is next. Let me give you an example of this. Alice Boland was charged with trying to kill President Bush and a Secret Service agent. She was adjudicated not guilty by reason of insanity, assigned to a mental health facility, released. None of that got in the system, went and bought a gun and went to Ashley Hall School and tried to kill the headmaster of the gun misfired. I think all of us would want that information into the system. Senator Klobuchar.
Thank you very much. Thank you for having this hearing, Mr. Chairman, Senator Feinstein. So about a year ago, I was at the meeting in the White House and sat directly across from the president, and we talked about these extreme risk orders. And as I said then, I come from a proud hunting state. I look at all of these common sense proposals about if they would hurt my Uncle Dick in his deer stand. They do not, and what they will do is save lives, and that includes universal background checks. And when we discussed this actual proposal, the vice president, who is sitting next to me, was positive about it. They have something like this in Indiana. And the president said he was interested in doing it, even at this point said you wouldn't need due process, which I believe he didn't mean to say. But he also said he was for universal background checks 9 times, I kept track, and we still haven't gotten this done. So I am frustrated. I hope we can get this through, but here on this anniversary month of Parkland, we still have not seen any positive changes. So I'll start with you, Ms. Wilcox. If we were to do something like this, could you just quickly talk about the importance of education so people, the citizens, know about it? I looked up your daughter, by the way, and she was a beautiful, smart young woman. I am so sorry what happened, and I am so just in awe that you were able to tell that story and help us to advance the ball on this bill. Thank you.
Thank you for that. Education's paramount with this bill. We will not realize the benefits, the life-saving benefits, unless the key stakeholders know about it. In California, we first thought we needed to be educating family members about this law. Then we realized we cannot educate family members if our courts and judges aren't ready to implement this. A family member in crisis most likely is going to call law enforcement, and they need to know. So education of law enforcement and first responders is paramount. In California, we've learned the challenge, I think, for law enforcement is how does this fill the gaps in existing law? We have our 5150 mental health hold law. The problem is there are many people who are in crisis, probably a situational crisis. They lost their job. They're angry at their boss. The wife's worried. He's talking about shooting his boss. What am I going to do? Or someone who's despondent, a new widow. The wife left the man, whatever. It's a situational crisis, emotional crisis that does not qualify for the kind of mental health prohibitions we have in California.
Okay, thank you. Thank you. Ms. Wyatt, could you just quickly go through some of the due process provisions that you have in your state law to get at a concern some people have? And then I have a second question. For years, I've been working to pass the Protecting Domestic Violence and Stalking Victims Act. And there's a House bill that's a bipartisan companion bill. We had 2 Republican witnesses back in 2014 that agreed that extending protections to dating partners would be a good idea. As the Racine County Sheriff said, dangerous boyfriends can be just as scary as dangerous husbands. They hit just as hard and they fire their guns with the same deadly force. Could you talk about the need to update our federal laws and start with the due process protections to get at concerns that might be raised about the extreme risk bill and then end with the domestic violence? Okay. Thank you.
Sure. To talk about due process, so I'm just going to walk you through what I would do, what a normal case would be like, and talk to you a little bit about that to explain it. So we would receive information either from law enforcement or perhaps from a family member that there's the at-risk individuals in a crisis. And when we're talking about crisis, we're focusing on words, actions, and behaviors of that individual. So the law enforcement officer or family member would fill out a detailed petition. I actually brought a copy if anybody wants to see what that looks like for our state. It's 5 pages long. It's similar, I would say, in some respects to doing a search warrant for law enforcement because you're attesting to these facts under penalty of perjury. So they're going to fill out this affidavit. They're going to come to the clerk's office. And I got to say that none of these processes are particularly convenient for anybody that's coming in to file orders, but this is the system. So they're going to come to the clerk's office, and then they're going to take their papers. They're going to go see the judge. They're going to go to the judge. Often ours are done ex parte because, once again, these are emergency orders, emergency situations. They're going to go into the courtroom. The judge is going to call them up, and they're going to be sworn in again. And then the judge is going to make a determination based on the petition and based on the information that they heard, whether or not it meets the standard to issue the temporary order. And then I want to say after that, then because this is being done on an emergency basis, of course the respondent, the person who's subject to the order, has to be served. So they have to have notice of it. Mm-hmm. So then they appear in our state within 14 days a hearing is set. At that hearing, our system requires the petitioner to be present to state to the court why they brought this action. The respondent is allowed to cross-examine the witnesses. He or she is allowed to call their own witnesses. And so it's almost like a mini trial in front of the court, and it varies per judge.
Okay. That's very helpful. Okay, just quick answer the second question.
So to clarify, including dating partners for federal legislation for protection orders and stalking, is that your question? Mm-hmm. I think it's critical. We are having this challenge currently in our state to expand possibly our categories of protection orders because it was based on the federal standard, which included you had to be married or have a child in common. So it's very important to know, to include the dating partners to give those folks protection because domestic violence defendants are the most dangerous in the whole criminal justice system. If you look at the data, they're the ones that are most likely to, obviously, if they're going to hurt their loved ones and hurt their children, they're most likely to kill law enforcement and others. And so I think it's vitally important.
Thank you so much for your work, all of you. Thank you.
Thank you, Mr. Chairman. Thank you to each of the witnesses for being here today and for testifying. The national epidemic we have of mass shootings and school shootings is a tragedy, and it is one that I believe we need to do significantly more to prevent. The state of Texas, tragically, has experienced this recently in horrific instances in both Sutherland Springs and in Santa Fe. I was in Sutherland Springs and Santa Fe in the hours following those shooters.
End gun terror. End gun terror.
Please,
Thank you,
either sit down or be removed.
Leadership. Thank you. Thank you, Jacinda Ardern, for your leadership. End gun terror. End gun terror. Assault weapons, assault people. Enough. Enough. Do something. Follow the leadership of Prime Minister Ardern. Do something. People are dying. You're killing them.
You will get a minute back, and you will continue.
Thank you, Mr. Chairman. As I said, I was in Santa Fe, I was in Sutherland Springs in the hours following those shootings, and what happened there was truly horrific. Sutherland Springs is frustrating because that crime in particular was easily preventable. The shooter in Sutherland Springs, it was already doubly illegal for him to purchase a firearm. He had a felony conviction, and he had a domestic violence conviction, as well as mental health issues. But in that instance, the shooter lied about his convictions when he purchased his firearms, and tragically, the Air Force, under the Obama administration, never reported his felony convictions to the background check database. We need to do much more, and in particular, I would urge this committee to take up and finally pass legislation that I filed over 6 years ago, the Grassley-Cruz legislation that I filed with the former chairman of this committee, that targets resources on bad guys, on felons and fugitives, that would have audited every federal agency to make sure that those felonies are reported to the background check database, which would have meant the Sutherland Springs shooter would have had his conviction in the database. But also critically, that mandates prosecuting the felons and fugitives who try to illegally buy firearms. Every year, tens of thousands of felons and fugitives go in, try to illegally buy firearms, and most of them are not prosecuted. Had Grassley-Cruz passed into law that Sutherland Springs shooter, when he lied on that form and committed another felony, he would have been prosecuted, he would have been in a federal prison, and he wouldn't have been in that beautiful church murdering those individual people. There is a great deal more we should do, but the right approach, I think, is targeting and focusing on bad guys, and I do think that extreme risk laws of the kind we're discussing can potentially be part of the solution set. That targeting those that pose an extreme risk, that have serious mental illness and pose a threat to themselves or others, is a law enforcement tool that can be helpful in preventing crimes of violence. Now, as has been noted by several witnesses. Policymakers have to balance the need to protect the public safety with also the obligation to protect constitutional rights and to protect civil rights. And so, Mr. Koppel, I wanted to ask you, in your view, what are the minimum protections that an extreme risk law should have to ensure that to comport with due process?
Sure. Use of ex parte proceedings only on a finding of necessity, as we have in Federal Rules of Civil Procedure 65. You can't normally just get a TRO against somebody because you think you have a good case. You have to demonstrate to the judge specifically why the other party isn't in court today and what attempts you made to contact that person, and if you're sufficient, then you can get the temporary restraining order. So ex parte orders only on a showing of necessity, a clear and convincing standard throughout, because if we're eventually going to have a hearing with a clear and convincing standard, an ex parte hearing ought to be a fairly easy thing to win with no opposition. Right to counsel, including ideally providing appointed counsel for respondents, guaranteeing their right of cross-examination, for public safety and avoiding trouble, a Vermont-style system where the subject of an order, the respondent to an order, may surrender the guns either to law enforcement or to a federal firearms licensee, a gun store, or to another responsible person who will store the guns and keep them away from the respondent, and a civil remedy for false or malicious accusations. Those are what I'd say is the core, and obviously my 27-page testimony gets into some more features, but those would be the most important.
And am I understanding you right that in your judgment of the different states that have enacted these laws, you think Vermont's is the best constructed and strikes the best balance?
In those regards, I would say that Connecticut has probably the best procedures for starting things because they require anybody, dating partners, employees, teachers, anyone can go to law enforcement or to a state's attorney's office, but there's the filter of having a law enforcement or state attorney's decision on bringing it, and Connecticut specifically requires that there must have been an independent investigation. You can't merely proceed on allegations that have no corroboration.
One of the things that you discussed in your written testimony was efforts of some of the gun control organizations to block the drafting of a model red flag law in the Uniform Law Commission. Can you describe that at some additional depth?
Sure. So when the Conference of Chief Justices, which represents obviously all the Chief Justices of the 50 states, and I believe the territories and the district, asked the Uniform Law Commissioners, which for over a century has been drafting model laws on many, many topics, to create a national model law. And obviously, it wouldn't be a uniform act that everybody has to adopt or implement unchanged, but a national model law for states to use as their starting point and adapt to their circumstances. And so we had a in-person meeting of the study committee that was created for this in late November of last year, and then 2 telephonic meetings, which had some of the original people there and then additional people. And we talked and argued some about different topics here, like ex parte, among others. And then the head of the committee took a poll and followed up by email voting. And all of the comments, except from one organization, were, yes, let's go ahead and do this, and we'd be happy to participate in the process. And the one organization that has its own very different model, which I view as going way to the extreme, said, no, we don't think you should do this because obviously it'll be a competitor to our group.
Which organization is that?
That was the Giffords organization.
Okay. All right. Thank you. Thank you, Mr. Chairman.
Senator Coons.
Thank you, Chairman Graham. Thank you, Ranking Member Feinstein. I'm grateful that we're holding this hearing today and working to try and find ways that we can support state efforts to enact gun violence restraining orders and then support them through training, through investment, through outreach and education. I do think that while we continue to respect and uphold the Second Amendment rights of all Americans, we also need to find responsible ways to deal with a crisis in gun violence around our country. And just at the outset, I'll reference both Senator Cruz and Senator Cornyn referenced the Sutherland Springs killings where 26 individuals were killed and 20 injured, and the importance of dealing with background check denials, in particular lie and try efforts, which are not currently as thoroughly enforced as they could be. I am thrilled that Senator Toomey of Pennsylvania is joining with me today in reintroducing a bill that says when someone goes in who is a person prohibited and lies and tries to buy a gun from a federal seller of firearms, federally registered, that there should be notification to state law enforcement if that individual has lied and tried. Currently, there's a dozen states where state law enforcement is the principal point of contact. Pennsylvania is one of them. So there's immediate notification to state law enforcement of what is a significant warning sign of someone who may well now try in another way to get access to a firearm. But there's 30 states where that's not the case, where federal law enforcement does the background check. Delaware is one of them. Texas is one of them. And state law enforcement in Delaware has unanimously responded that they would welcome knowing when a person prohibited, a convicted felon, someone who's been convicted of domestic violence, someone who is prohibited from owning a gun, when they go into a licensed firearm dealer and lie and try, they would act on it. And it would have, I think, a positive outcome. So it's my hope that other members will consider again joining. It was co-sponsored by a number of Republicans and Democrats in the last Congress, and I think it's exactly the kind of next step we should be taking. If I could briefly, Mr. Hunberg, just thank you for NAMI and for what you do as advocates. When I was in county government and responsible for a county police department, we had a truly tragic and unnecessary shooting that resulted in the death of a mentally ill individual. NAMI came in and really helped us train our department in terms of de-escalation, how to better understand mental health and how to interact with individuals with mental health in ways that destigmatized. And Sheriff, it sounds to me as if you've done a tremendous job at integrating mental health professionals into your law enforcement response. Ms. Wilcox, words cannot express the depth of my appreciation for what you and your husband Nick have done to take an incredibly tragic loss. Laura went to college very close to where I live. I know young people who are students at Haverford. My own twin boys are 19 and freshmen in college. And the idea of losing them to an act of senseless gun violence like that is beyond what I can imagine any parent bearing. And that you've then turned this into effective advocacy is, to me, a truly inspiring story of what families can do. Let me just ask, if I could, both Ms. Wyatt and Ms. Wilcox, in the brief time I have left, just tell me, do you think that sharing Nick's background denial information with state and local law enforcement would help make our community safer? And how would that contribute to then being able to act on the potential for gun violence where someone who is a person prohibited has gone in, lied, and tried to buy a gun?
I'll go first.
Sure.
Yeah, my terminology is investigating denied purchasers.
Mm-hmm.
So this is someone who wanted a gun
Yep.
and was prohibited, presumably because they committed a crime or had a mental health prohibition, and were considered dangerous of a future act of violence if they had a firearm. So they want a gun, and I think it would be very wise for law enforcement to investigate the circumstances and actually whether they had also been able to somehow acquire an illegal gun at the same time. California notifies the jurisdiction where the gun was purchased, and there is pending legislation to notify the jurisdiction where the person resides, the law enforcement in that jurisdiction, which makes more sense.
Ms. Wyatt and Sheriff Bradshaw, if you just comment briefly, would this be a helpful tool in the toolkit to de-escalate or perhaps intervene if there is an emerging crisis with someone who's also trying to get access to a firearm?
Absolutely, and we have this law in our state, and I can tell you that we've had 2 individuals who had extreme risk protection orders against them, and those two individuals went on to try to purchase. And they were charged, I believe under our law, they were charged as gross misdemeanors. But certainly this is vitally critical information, especially for victims and families, right? So we're tracking both domestic violence offenders that are trying to purchase, as well as following the extreme risk protection orders. So I think it's vitally important for community safety.
Thank you, ma'am. Sure.
Yeah, I would take it one step further. You know, with the gun shows, you have people that go and do what we call straw purchases. The gang people are really good at this. They'll get somebody that's, you know, clean on the face, go in, here's the laundry list of guns, take out, and now give them to the bad guys. So if we're going to do the lie about getting the gun and do something, we need to do the same thing with those people that are involved with the straw purchases. We monitor that very heavily, and we catch those people on a regular basis.
Well, thank you. Thank you all both for your testimony and for your service to our nation. Thank you, Mr. Chairman.
Thanks, Senator Hawley, for letting Senator Lee go next. I think you've got a appropriation committee. Senator
I
Lee.
appreciate that, Senator Hawley. Thank you for what you said about straw purchases, Sheriff. I've been very, very impressed with your testimony anyway. But the straw purchases, why we don't find ways to close that, close the gun show loophole, that should be easily done. Have real record checks. Now it's in paper because one of the gun lobbies didn't want us to have electronic. People have been afraid to vote to have real background checks. I spent 8 years in law enforcement. I know how much better it is if you can do a real background check. In fact, I think that what we ought to do, you know, there's lobbies one way or the other on this issue. Let's bring the issues up and vote on them. Vote them up or down. I'm perfectly willing to do that. Instead of just talking about it, let's vote them up or down. And we did this to get rid of bump stocks, and now it looks like the Supreme Court is going to uphold what we did there. That's one step forward, but there's so many large magazines. We don't need that. You know, in my state, they limit on your semi-automatic to 2 or 3, I think 3 or 4 rounds during deer season to give the deer a chance. I'd like to see children given a chance in their schools and make that illegal. Close the gun show loophole. I mean, this is ridiculous. That somebody can come in and they can have a felony record and buy 5 guns at a gun show. And I'll tell you, who would appreciate that? Legitimate gun dealers would be. They're paying taxes, they have to follow the law, and they see these guys selling them, and that's where your straw purchases, as you know, come in. Anyway, I don't mean to give a lecture. I come from a state which has, Mr. Koppel has talked about its law passed. That was signed into law by a Republican governor in a state that has a very large percentage of gun owners. And I didn't hear many people too concerned about it, having tough laws. Ms. Wyatt, I'm delighted to see you here.
Thank you.
I remember a long time ago, as a prosecutor having a case with the King County prosecutor, went out there. I think it was extradition. I suspect the office a little bit smaller than it is today. But in Washington State, if you want an initial temporary order, you say you have to prove there's reasonable cause to believe the individual poses significant danger. For a longer order, you must prove it by a preponderance standard used in almost all civil litigation. Reasonable cause is akin to probable cause in the criminal law context, right?
Correct.
Thank you. Same procedure that must be used in ex parte proceedings to obtain a search warrant, enter a person's home and take their property, even make an arrest.
That's correct? Yes.
Now, you've been a prosecutor for nearly 2 decades. Actually, being a prosecutor is the best job I ever had.
Thank you.
Have these standards of proof struck the right balance?
I'm sorry, can you repeat that, sir?
The standards of proof that you have, probable cause, reasonable cause, these standards struck the right balance?
I believe they have. And just to offer a comparison, in our state, when we're looking at clear and convincing evidence. That is our standard that we use to terminate parental rights for somebody. So those are dependency proceedings that are at that high burden of clear and convincing.
And you have a specific team just designated for that. Is that correct?
We do. We work on we work on firearm enforcement with folks that are subject to other protective orders, so domestic violence, stalking, and sexual assault, and as well as extreme risk protection orders, yes.
That's somewhat unique around the country.
It is.
I applaud you for it.
Thank you.
Mr. Hohenberg, do you feel it's important that extreme risk protection orders focus on, let me read this, be correct, specific dangerous behavior rather than a mental health diagnosis?
Yes, that is correct, Senator Leahy. And I know I'm sounding a little bit like a broken record here.
Oh, go ahead.
But we know that 4% of violence in this country is attributable to mental illness. That means that 96% of violence is not. So if somehow, miraculously, we were able to cure mental illness, which we're far from being able to do at this point, we would not be appreciably reducing violence. So, and I think it's really important not to paint serious mental illness with an overly broad brush. Are there a subset of people who may pose risks of violence? Yes. Most people don't. And there's also, we know that young males pose an increased risk of violence, but we know that most young males are not violent. So I think it's very important that we talk carefully about this. And what I like about these laws is that they really provide as close to an evidence-based approach to identifying and responding to risk of violence than anything I've ever encountered. Thank you.
Thank you very much. Thank you, Mr. Chairman, and thank you, Senator Hawley, for the
Senator Hawley.
Thank you very much. Thank you, Mr. Chairman, Ranking Member, and thanks to each of you for being here and for being willing to testify and share your experience on this extremely important subject. And I want to express again my concern in the growing epidemic of violence, particularly I think youth violence that we're seeing around the country. And I hope that we can look and that this committee and others will look into not just the after the fact results of this terrible violence, but the causes of it, the social causes of it, and including the role of perhaps social media and others in driving this youth violence, which I think is extremely important. I've looked at the different statutes around the country, the 14 different states in the district who have laws like the ones we're talking about today, and they vary quite widely, as we've discussed. And as a former prosecutor, former attorney general, of course, I'm very concerned that we protect the due process rights of all persons involved while keeping weapons out of the hands of those who are criminals, those who are a danger to themselves and others. And that, of course, is a balance we have to strike every day in the law. I mean, we do this in many contexts, not just when it relates to the Second Amendment rights, although the Second Amendment is a fundamental right, as the United States Supreme Court has said. But it is a familiar balancing act we have to perform in the law, and certainly need to perform it here. Mr. Koppel, let me just ask you, I want to come back to something you were saying to Senator Cruz, talking about the differences in these laws. You noticed, you pointed out that Connecticut, you said you think in many ways their initiation process is an ideal one. And I take it you think that because it requires a state's attorney or assistant state's attorney or a law enforcement officer to initiate the proceedings. Can you just say more about why you think that is a good process that's protective of due process?
Sure. As there are lots of people who might know about somebody who does pose an extreme risk, but and there are also lots of people who might, just as they take advantage of lots of other laws about alleged child abuse or domestic violence and things like that, in ugly divorces and in situations, false accusations do happen, sometimes often. And so Connecticut has, I think, a good filter on that, which is anybody can go to law enforcement and then ask them to initiate this petition. And law enforcement then has the two officers or a state's attorney has the obligation to conduct their own independent investigation, and based on that, they go forward. Now, even so, we still have a high error rate, 32% error rate, even with the law enforcement as the filter. But I would suggest that that's probably
that's in Connecticut, 32%.
Yes.
Uh-huh.
Yes, but when you broaden the scope of anybody who can come in for any reason, sometimes with good intentions and sometimes not, that would tend to, I think, make the error rate even worse. In Colorado, certainly a lot of the legislative testimony we've heard about the bill that's before our legislature has been many women who were in divorce proceedings and said, I'm terrified of this bill because because the Colorado law allows a huge number of people to initiate. And as a woman said, if this bill had been around when I was getting divorced, my husband absolutely would have used it against me. And we've heard that from many, many people. So I think the law enforcement judgment is an important part of practical due process protection.
What do you think are some other states whose procedures across the range here are good models as you look at these laws?
Well, the Colorado law has something. It's not quite law yet, but it's going to be, provides for court-appointed counsel for all respondents. I think that's an outstanding feature, and that's exactly the kind of thing that federal funding could encourage. Vermont does a good job at de-escalating, the popular topic, I think, among everyone on this panel, de-escalating the confiscation process. Instead of having the law enforcement automatically show up and say, ex parte, I'm here to take your guns. Instead, the person who's subject to the order can, rather than having the guns hauled out by the police, can give them to a federal firearms licensee like a gun store or another responsible individual. And obviously that's something that has to be done quite promptly, but it's less confrontational than forcing law enforcement to walk off with someone's guns. Sometimes there are situations where law enforcement absolutely should, but that doesn't always have to be the mandate. That can be more the judgment of the officers and the courts.
Great. Thank you. Thank you, Mr. Chairman.
Thanks, Mr. Chairman. Let me begin by thanking the chairman, Senator Graham, for his courage and insight in having this hearing and in recognizing the importance of a sensible, common sense approach to guns in the hands of dangerous people. As litigating attorneys, we both recognize the importance of due process, and as respecters of the Constitution, we certainly acknowledge the importance of the Due Process Clause and of the Second Amendment. It is the law of the land, but at the same time, keeping guns out of the hands of people who all but put an ad in the newspaper that they are going to kill people in a school in Parkland simply is intolerable. And I have just come from a group of Parkland students who are visiting the Capitol today, and I want to say that they would very much respect you, Senator Graham, for having this hearing, and I appreciate it. I also want to recognize some of the folks from Connecticut who are in the audience today. I don't know whether they are still here, but Melissa Kane and Poe Murray, leaders of the gun violence prevention movement in Connecticut, and Kristen and Michael Song, who lost their son Ethan because of a killing that was the result of failure to safely store a firearm. And their courage and strength have inspired me. And they remind us, Sheriff, of what you said at the very start. There is no end-all, there is no panacea, there is no single solution here. It has to be a comprehensive approach, including, in my view, the background check law that the House recently adopted. I hope we will do so in the Senate, and other measures that have been endorsed and supported by members of this committee, including myself. But the extreme risk protection order will make us safer. It will help save lives. And I want to take serious issue with the contention that a 32% reconsideration rate reflects errors. In fact, on the contrary, I am proud that judges will review new facts, that people who are out of crisis may have guns returned, that we recognize that folks who may be regarded as dangerous because they are mentally ill, in fact, when more facts are known, have weapons returned to them. This kind of statutory framework can be done in a way that respects individual rights and protects people from danger to themselves, suicide. And let me just recognize the loss of a wonderful friend, a brave parent who lost a child at Sandy Hook, Dr. Richmond, Jeremy Richmond, who took his own life yesterday morning, a neuroscientist who was exploring the reasons why people are violent, what happens in the brain that triggers violence. Let me ask you, Dr. Wyatt, I'm sorry, Ms. Wyatt, Washington State has its statute. Is Washington State possibly safer if other states have similar statutes, even though Washington State has its own extreme risk protection order statute? Would you be safer with others?
Absolutely. And there's an issue of full faith and credit that we need to talk about too. Oh, it's not. Oh, I'm on. Sorry. Okay. I'm sorry. So there's an issue of full faith and credit as well. We want to make sure that when a court in any jurisdiction is issuing one of these orders, that individual cannot go to another state and purchase. And specifically, that has come up in these hearings. We've had respondents who've been subject to the full order tell the court, so can I go to a different state and purchase? And then the courts, and obviously that causes great alarm to us because the court has just issued that order and said you cannot possess or purchase a firearm, yet they're looking for other avenues to be able to do that. So I absolutely do think it would make Washington and other states much safer to have this universally done.
And let me ask you and the sheriff whether you think that safe storage laws, in other words, requiring that certain basics of safety be applied to storage of firearms, also eliminate some of the risks of firearms violence?
I'm not an expert on that subject. I think it makes common sense. It's a common sense risk reduction tool, but I can't speak to it in great detail.
Well, there's no doubt about that. We've already had a couple incidences in South Florida where young children as low as 4 years old have shot themselves with a firearm that wasn't properly secured. And fortunately, the parents were prosecuted for that, not having done that. But I'd like to go back to something that you said that's important. One of the beauties of when I created this unit is aftercare. Just because we put them into a facility and the facility says after 72 hours you're okay to go out, that doesn't mean you're okay like from here on out. That just means you're okay and you're stabilized now. So part of what my unit does is stays in contact with the family. If it's a juvenile, they'll work with that. If it's an adult, make sure that there's some aftercare, some follow-up, work with the family, make sure they're on their medications. But when it comes time for the hearing for follow-up to see if, in fact, those guns should be back, the deputy and that mental health provider, service provider that's the partner with us will go in there and be able to say to the judge, yes, we've done the follow-up. We've worked with this family for the last year. We believe that they've turned the corner and he's stabilized and they have the opportunity to get it back. I think that's an important part of what happens in these hearings.
Thank you. Thanks for making that point, and thank you to this excellent panel. Thanks, Mr. Chairman, for putting it together. Every one of you, thanks.
Yes, thank you, Chairman, and to all of our witnesses. Thank you very much for making the time to come in and be with us today. I appreciate that very much. The red flag laws that we're talking about here today don't exist in a vacuum, and the rights and protections enshrined in the Constitution need to have a front row seat in this discussion because these laws will apply to every American regardless. Why is this important? Because the red flag laws that we're talking about today will, whether justifiably or not, will deprive individuals of a constitutional right. And this isn't something that any of us take lightly. Any red flag legislation that comes before this committee or the Senate as a whole, should we proceed, needs to include the utmost protection for due process rights of Americans, and many have spoken about that today. It does need to be narrowly tailored and show a strong respect for the right to keep and bear arms. I'm not opposed at all to examining the role that mental health plays in gun violence. I do think that this is very, very important and necessary as part of this discussion. Suicide and the tendency to use firearms to commit suicide is an issue that we very much need to address. Mr. Holmberg, I want to talk about the issue of suicide with you, please. In your testimony, you note that in 2016, the U.S. Department of Veterans Affairs reported that about 20 veterans per day take their own lives. You also note that we've seen a rise in suicide rates among young veterans between the ages of 18 and 34. Now, this is a tough question to answer, but what accounts for the discrepancy in suicide rates between veterans and civilians, in your opinion?
Well, I would hardly cast myself as an expert on suicides, but you know, many of our veterans, particularly our young veterans, have experienced and have heroically defended our country and have experienced horrific circumstances that most people have not experienced in their lives, and come back and need services and supports. And again, I want to be very careful not to cast too broad a brush here.
Absolutely, thank you.
But I think that it's very important that we reach out and support veterans, and that we have access, that we provide people with access to treatment, and that we also convey the message that it's okay to acknowledge that you may need some mental health care. And that's why it's so important for us not to talk about mental illness only in the context of violence and criminality. Because the fact is that, you know, we're all vulnerable to mental health challenges under the right circumstances. So we really need to create an environment that's supportive of people stepping up and getting help. And I think that has real relevance to how we deal with issues around extreme risk protection orders and the background check system, et cetera.
Yes, I would think that that would be a very delicate balance, because as a former commander serving in a combat zone during Operation Iraqi Freedom, I know that many soldiers are returning veterans that do need to seek assistance. Many of them may be reluctant because of the stigma that would be attached to that, but then also the fear of, if they are seeking assistance, mental health supports, behavioral health supports, that then could that be used against them to take away their rightfully owned weapons. So it is something that does need to be considered as we move through any potential discussions in this area. And then how often does somebody exhibit an external indicator of suicide?
It varies from case to case. There's some people who speak fairly openly, and where those around them may be very aware that they're vulnerable, and other people who tragically do not give indications. And one thing about suicidality that I think is also relevant to this discussion is that sometimes and I don't want to discount it, it's an impulsive act. A person feels overwhelmed at that particular point in time. And if steps can be taken to intervene and prevent the person from acting, they may never act again on those impulses or even feel those impulses, which is why creating an environment that even allows people to voluntarily relinquish means that they might have for taking their own lives would be a very productive step to take.
Now, again, because my time is expired, I do want to thank everybody for being here today. These are circumstances and discussions that we absolutely have to have, but simply we want to make sure that there is due process in place for all of those involved as we move forward. So thank you all very much for being here today. I appreciate it. Thank you very much, Mr. Chair.
Thank you. Senator Booker.
Thank you very much, Mr. Chairman. I want to thank everybody for being here. I'm really grateful for this hearing. I want to thank the panelists, as well as many of the people in the audience who came here, who are really following along and pushing this debate forward. There's just too much carnage in our country. I'm 49 years old, and in my lifetime alone, there's been more people who have died in our country due to gun violence in all the wars combined. And going back to the Revolutionary War, it is a stunning amount of pain and hurt and agony that shakes me at my core. Something has to be done. And I'm grateful for the chairman for holding this committee. I am deeply grateful for him for stepping forward to do this. We have got to do more, though. We've got to pass common sense gun safety laws. I can't believe that we watched New Zealand come together as a country within 7 days of a mass shooting and do something. Now, we may not agree with their tactics or their strategy across the aisle, but we can do so much more. There is so much common ground on this issue. We are the world's most deliberative body. There are common sense solutions. A lot of things being put on the table by senators from both parties that could make progress, obviously not solve the entire problem, but could help to save lives. Something as simple as background checks. I was in Iowa in a diner with a guy with a MAGA shirt on, and we sat down and had a conversation. He came at me hard in the beginning, thinking I was a Democrat and therefore wanted to take away all his guns. But when we could cut through the partisan rancor and actually have a conversation, we ended up hugging each other and agreeing that we need universal background checks. He agreed just like me that we cannot have a country where somebody on a terrorist no-fly list can then walk in and buy a trunk full of weapons at a gun show. These are things that are so common sense that over 90% of Americans, over 86% of gun owners don't understand why we as a body can't hold a hearing, have a vote on that legislation, and put it on the Senate floor. There's something really wrong with a society that can't get things done where overwhelmingly the majority of people agree that we need to get it done, and what's the consequences for it? I think I'm the only senator that lives in a neighborhood where there's regular shootings. My senator has done something about it. My mayor has done a lot to reduce the violence, but across the street from me 2 years ago, young man shot. At the top of the block where I lived last year, Shahad Smith murdered with an assault weapon. When we have 4th of July in my city, you get parents telling you stories of kids hiding in closets, exhibiting the behavior of people with PTSD in our communities. Black men make up 6% of this nation's population, yet we are more than half of all the victims of homicides each year. And so this is something that is very painful to me, that we can't do something to address these issues. And I'm tired of seeing sidewalk shrines to dead children in my community and in cities all across America, and people doing nothing to put gun safety laws in place that we agree with in terms of getting it to a vote in this body. My friend across the aisle just read the suicide statistics. I don't want to gloss over them. She rightfully pointed out, your testimony, Ms. Honberg, is stunning. This one page of your testimony where you just rifle through things that should shake the core of everyone. You call it an epidemic. Not just affecting young people as a top reason for death between 10 and 24, but our veterans, as Joni Ernst pointed out. 20 a day. And so it is hard for me to go home to know that when I hear gunshots that echo, that hurt, that destroy communities. My friend who works at an IHOP who desperately needed the 2 shifts she had to pay for her family. One shooting in front of that IHOP cut business to that business, and they had to eliminate a shift. These things ripple out and destroy people's lives. And what we've seen in Parkland recently with the suicides. So I'm just hoping that it's good to have a hearing. God bless you, Chairman, for holding this hearing, but let's have some committee votes on the stuff that's bipartisan. If the guy in a diner in Iowa that wearing a MAGA shirt that sees me as the way we view each other across partisan lines, but he and I can come to an accord, then we in this body should be able to come to an accord and have some votes, at least in this committee, have some votes on common sense legislation that any poll will show you that overwhelmingly gun owners in America say, yeah, we should do that. Lindsay will tease me later on if I don't get one question in. And so I just want to ask, I have this problem that we don't see this as a public health crisis. The CDC is not even allowed to have funding to research gun violence, and something I'm sort of confused about, that we would starve from viewing this as a public health crisis that it is. So maybe, Ms. Wilcox, I can direct my sole question to you and just ask, what does a holistic approach to gun violence epidemic look like to you? And maybe what else should the Senate Judiciary be focusing on as we try to move forward to some votes on common sense gun safety?
I'm glad you mentioned research. I'm proud that California established the University of California Firearm Research Center so that we can further dig into what's working and what's not working. California, I know, is different than the nation on this regard. I live in a rural county, however, and I meet with gun owners all the time and people who think they disagree with me all the time. And by the end of the conversation, we find that there's much common ground. And I would say the two policies where there's most consensus over is background checks for all gun sales. That makes sense to most people. And the other is extreme risk law. Everyone knows of situations where there's someone dangerous. Maybe mental health, probably more often it's a situation, emotional crisis. And everyone agrees, an extremely dangerous person, heightened anger in a crisis, probably shouldn't have a weapon. So I believe there's more consensus than our politics and our nation allows us to realize. And I'd just like to mention, we have to remember what's at stake here. And it's not just the shooting that happens that day. I mean, we're finding out now what happened a year ago in Parkland with 2 students who killed themselves last week, and after Sandy Hook, a father who killed himself. This issue does not go away for those families. And at the very least, let's proceed on these policies where I do think there is some broad agreement, and figure out how to get it right and how to move this forward.
Thank you, Ms. Warren. Thank you, Senator Booker, for those kind words. Jeannie Hoyer's here with the Parkland families today, and just want to recognize that. Senator Hirano.
Thank you, Mr. Chairman, for holding this hearing so we can hear from the panel, and also to learn that blacks constitute 60% of our population but represent over 50% of homicide victims in our country. Yesterday, some very dedicated young people involved with the March for Our Lives came to my office to deliver letters from my constituents asking us to tighten background check requirements and to support S506, Senator Feinstein's red flag law. And their activism and advocacy in favor of laws to reduce gun violence is inspiring. And I challenge the adults in the Senate to rise to their challenge. And it's been mentioned how the horror of Parkland and Sandy Hook continues to play out in the tragic suicides of a number of the people there, and it really breaks our hearts. There are many supporters of the red flag laws and other sensible gun legislation in our audience today, as well as those who are standing outside listening to this hearing. And yes, there is a constitutional right to bear arms, but no constitutional right is unfettered. That's why we're here today. Mr. Koppel, you are the research director of something called the Independence Institute, which has received over $1 million from the NRA, and the NRA's driving purpose is to represent companies that make and sell guns and to withstand all efforts on our part to enact sensible gun legislation. So one wonders how objective you are on the issue of safer gun laws, but let me ask you and Mr. Hornberg this question. Almost 25 years ago, the Congress passed something called the Dickey Amendment, referenced by Senator Booker, which prohibits the Centers for Disease Control from using federal funds for doing research into preventing injuries from gun violence. Do you think that makes sense, that we would be so afraid of research that we have to set aside the use of federal funds to study the impact of gun violence in this country?
Was that a question to me, Senator?
To you and to Mr. Hornberg.
Well, I suppose one of the things...
Very briefly.
Briefly,
yes or no? Do you think this even makes sense to set aside, the study?
Your question isn't your premise on the Dickey Amendment is incorrect. The Dickey Amendment forbids use of federal funds for advocacy. It does not forbid federal funds for research.
Well, advocacy is often in the eyes of the beholder. So, Mr. Hornberg, would you like to weigh in?
I'm going to respond just to the question about research. I think today what we've been talking about is an evidence-based approach to preventing gun violence, and I think the more research we can do to learn what can be done to prevent gun violence and some of the tragedies that we've been talking about today is something that we would strongly support.
So you don't think it makes a lot of sense to have to be so afraid that we're going to set aside prohibit the use of federal funds for, you can call it advocacy research?
Well, I don't know enough about the Dickey Amendment to comment specifically on that, so I really wanted to just...
Well, it's as I described it, so I would say that if you care about fact-based research, you wouldn't want to set aside money that would be otherwise available. Ms. Wilcox, thank you for all you've done to turn your grief into action. And you spent many hours in Sacramento explaining the benefits of red flag laws to California legislators. What do you think is the most misunderstood or mischaracterized aspect of red flag laws that you think could persuade those who are undecided about them?
I think many people think it's just for people with mental illness. And as we've heard, and Mr. Homburg said so well today, most people with mental illness are not violent. And I'm saying that as someone whose daughter was killed by a mentally ill person. He was severely mentally ill. There is a category of severely mentally ill people, persistently mentally ill, who are not in treatment, who may be more violent, but in general they aren't. We need a tool for disarming, with due process, disarming a person who is at heightened risk of dangerousness, maybe because of the condition, mental health, maybe because of heightened anger, maybe because they are in a temporary crisis.
Go
ahead.
Thank you. I think that's a concern that we have. So, Mr. Hornberg, does Senate Bill 506 provide the kind of language that would ensure that we're not imposing these limits on people with who have been diagnosed with mental illness? Are you familiar with the provisions of the bill?
And having read it, and also having read the bill that was introduced, the bill that was introduced by Senator Rubio. First of all, I think it's terrific that there's a bipartisan effort to try to pass a law authorizing extreme risk protection orders. Having read S506, I think there's strong due process language in there, and I also like the fact that there's some attention paid to the importance of training law enforcement responders, and for doing outreach and community education. I think those things are critically important.
Thank you. Thank you, Mr. Chairman.
Thank you. I believe that's all of our senators. Excellent panel. Thank you all for coming. I'm far more enlightened than I was before, and we'll see if we can plow ahead and find that common ground. And Mr. Koppel, I'm sorry that you couldn't find a uniform law, but maybe we can get a group of the willing to come together. And each of you in your own way gave a lot of insight to. I really can't see a reason why we can't pursue this at the federal level, to incentivize states to do what others are already doing. And the benefits are enormous. If you can just stop one, that's enormous. And there has to be due process. We all get that. And it seems between Connecticut and Vermont and Indiana, you can make a stew here that works. So we'll keep working. Thank you all. And anybody who would like to submit something for the record, you can do so in the next few days. And hearing's adjourned.
Thank you.
Well, guys, that's the end of that. They finally got it done. But that senator, whatever her name is, out of Hawaii there, she put it out plain, and it's what I've been saying for quite a while now about the NRA. They're there to protect companies that sell guns and help with common sense gun laws. That's it. Not what the majority of the population thinks the NRA is even about. They're out there for money, and that is it. And I've used a very good analogy in the past, and it still holds true. The NRA is like your local heroin dealer opening up a rehab center. They collect money on both ends. They cause a problem, like this red flag mess and the bump stock ban, which is directly their fault. And then they go out and campaign to get money to help fix a problem that they caused. People need to wake up and get rid of that organization. There's Gun Owners of America. There's a new one that's come about, which is very good, American Firearms Coalition. There's several good groups out there. NRA is not one of them. If anybody owns a bump stock, you're now a felon. That went into effect. So, remember that. I'm not going to tell you what to do one way or another, but use your head. So that's pretty much all I've got for time being. If anything else comes up or I hear anything or any other hearings, whatnot, I'll be sure to jump back on and bring it to you guys. So make sure you smack the bell thing. So hopefully, if you're one of the lucky ones, I guess, YouTube will actually let you know when I go live. But we gotta stay on top of things as much as possible. And I'm gonna post a link. Give me just a second here. Let me find it. Here it is. This is automated. You really don't have to do nothing but use it. Click that link that I just posted, and that will auto fill in all your information. And you can, with one push of a button, email all your representatives. It's pre-written. They never read this stuff anyway, but you need to just burn up their email. It's got their phone numbers. You can call, do all that kind of stuff. Let these people know what you think. They know all about us anyway, in one form or another. So, don't think you're going to be telling on yourself that you own something. Forget it. Put it out there. I don't even want to call these people leaders. They're people that we've hired in. They work for us. So, remind them of that. Election time rolls around. They could be out of a job if they don't straighten up and fly right and do what they're supposed to. So that's, like I say, pretty much what I've got. One last thing that I do want to add, which is off topic, but nevertheless, I'm going to put it out there anyway. Go check out my second channel. It's still new. I've only got a handful of subscribers, but if you got any interest at all in the UFO stuff, go check out my Central Ohio UFO Reporting Center. Links in the description as well. If you go to the bottom of my homepage, you'll see the YouTube icon. Check that out, and if you want to sub to the other channel, go for it. So take it easy, guys. Stay safe, and I'll catch you next time.